I've been asked, why did I take so long, more than 2 years, to act? It's a fair question. In retrospect, and certainly now knowing how things eventually turned out, I agree. I should have forced the issue sooner. There is no single template that applies to all extramarital affairs, but there can be at least 3 situations. The first situation is where the individuals involved will be talked to, and if they stop, the matter ends there. The second situation, where immediate action has to be taken. For example, when one party has supervisory power over the other party, and we have in the past taken immediate action in a few cases. Third situation, where the relationship raises some questions of propriety beyond it being an extramarital affair per se. The parties will be talked to, but the matter cannot end there. Even if the affair stops, some action has to follow. But what that action is and when it is taken depends on the nature of the facts and the boundaries that have been transgressed. The present situation falls into this third category. It's wrong. Mr. Tan and Ms. Cheng had to stop their affair. I told them to stop. After I spoke to Mr. Tan in November 2020, he told me that the relationship would end. I took it to be so. I therefore felt there was some leeway to take some time to decide what further steps to take. In this context, the possible actions that could have followed were, on the basis that the extramarital affair had stopped, I would have asked Mr. Tan to step down as Speaker sometime before the end of the term, but in a way which would reduce the public embarrassment to him and his family. As to whether one or both should also resign as MPs, I hadn't decided at the time, but quite likely both would have had to leave at some point. But by giving the matter some time, I had hoped to give them a softer exit and save them and their families the pain and embarrassment that they are suffering now. I place much weight on protecting their families, perhaps too much. When CPIB discovered on its own that it had reason to arrest and interview a minister, it opened a formal investigation. Nobody tipped them off. There had been no public scandal. CPIB came across something that needed investigating and proceeded to do their job. When the Speaker of Parliament and a government MP fell short of the standards of propriety and personal conduct expected of them, they were asked to resign. We took some time to sort it out, probably longer than we should have, but we did what we needed to do and put the situation right. With the investigation into Minister Iswaran and the resignations of the Speaker and an MP, the PAP has taken a hit. But we will show Singaporeans that we will uphold standards and do the right thing.
While CPIB reports directly to the Prime Minister, it is functionally independent. CPIB does not require the Prime Minister's concurrence to conduct its investigations. Under Article 22G of the Constitution, in the event the Prime Minister refuses to give his consent to a CPIB investigation, the Director of CPIB can go directly to the elected President for his or her concurrence to proceed with the investigations. In reality, we have never had a Prime Minister who has impeded CPIB's work.
I think we are reading a lot into very little. First of all, nobody knew that Mr. Iswaran might or might not have been doing something wrong. CPIB found out. Nobody tipped them off. Nobody blew a whistle. Nobody raised a public scandal. No PQ in Parliament, not even from the Workers' Party. But CPIB found out, and they told me, and they decided to investigate the matter. And they proceeded. It reached a point where they needed to interview the minister. And then they came to tell me and say, can I have your concurrence? Because CPIB reports to somebody. It has to report to somebody. It can't report to God. So who does it report to? Now, that's a very interesting question. Who is to judge the people who judge the people who judge the judges? Who is in charge? Somebody has to be in charge. And in Singapore, the Prime Minister is in charge. And if he is corrupt, you are sunk. But beyond that, we decided to put in an extra safeguard. And that is, if the Prime Minister directs the CPIB, you don't do that. CPIB can go to the President and say, Prime Minister has refused me consent, do you concur? And if the President says yes, then the Director CPIB can proceed. If the President agrees with the Prime Minister that the Director CPIB does not have a case or has gone rogue or is doing something ill-founded and says no, well, that's how two keys work. And therefore, the matter stops there. Is it guaranteed? No, because the Prime Minister may be corrupt, the President may be mistaken, but it's as best it is possible to contrive a system with human beings which will work, provided you put honest people in charge. That's how the system is supposed to work in Singapore.
So in this term of government, the government has either been slow to clear the air or been less than upfront and forthright with Singaporeans when it had to deal with potentially embarrassing issues. I will give 3 examples that capture this point, and my clarifications will be contained therein. Firstly, in May this year, the public was not informed forthwith that CPIB had been instructed to look into the ride-out road rentals by 2 ministers. On the 23rd of May, the Prime Minister released a statement stating SM Teo Chee Hean had been appointed to establish whether there had been any wrongdoing in the ride-out road rentals in order to maintain the highest standards of integrity in government. What the Prime Minister did not tell the public, but was made known by way of a statement from the Prime Minister's office written in the third person on the 28th of June, was that the Prime Minister had directed the CPIB to investigate the ride-out road matter on the 17th of May, a full 6 days before his 23rd May statement, that omitted to mention that he had ordered a CPIB investigation into 2 of his ministers. The public came to know about the CPIB investigation more than a month later when investigations were completed, with CPIB confirming no criminal offence was disclosed. Second, there is considerable public disquiet about the CPIB releasing a statement on the 12th of July which stated that Minister Iswaran was assisting with investigations while omitting to disclose the fact that Minister Iswaran had been arrested a day before. Has the Prime Minister inquired with the CPIB why it undertook such a course of action that brought unnecessary attention to the CPIB's processes and by extension even its impartiality involving the release of statements in the public interest? And if he did not, would he consider to do so? Thirdly, during COVID-19, the public was belatedly informed by a minister in this House that his senior cabinet colleagues were aware by October 2020 that previous government assurances on Trace Together being solely used for contact tracing were effectively false statements of fact. Misrepresentations had hitherto been made by various government ministers and possibly in this House even before October 2020, and they stood uncorrected for months. The PAP government took almost 9 months before it disclosed to Singaporeans that the Singapore Police Force sought to collect Trace Together data for an investigation in May 2020, even as the PAP continued to assert right through the rest of the year that Trace Together was only to be used for contact tracing. Unlike as represented by the PM, these are not events that I quote are clustered together, all coming at one go. Instead, they reveal a pattern of behavior over a period of time of the PAP engaging in half-truths on matters of significant public interest.
The leader of the opposition raises 3 issues, one of which has been extensively debated, in fact, in 2020 during COVID, and I don't need to go back there again, which is the Trace Together and whether we should have announced earlier when we discovered that the police were using it for their purposes. I think that has been completely explained, closed. That matter is done. As for CPIB statements, the CPIB doesn't investigate somebody unless there is a very serious reason to do so. And the CPIB doesn't reveal that investigation generally until it has reason to believe that this investigation has to carry on, that it has to go somewhere. Therefore, in general, CPIB investigations are not in the first instance announced at all. And when I ask the CPIB to investigate, it's my prerogative. I don't have to tell anybody. What is important is that I did conduct an investigation and the investigation results were published. That is what matters. In the case of the 12th July statement, the reason why the CPIB said exactly what they said, if you listen carefully to Minister Chun Sing, that explanation has been given, which was that they had to say what they felt justified in saying at that point for operational reasons and to be fair to the persons involved, and the ministers, unless we have strong reason to do otherwise, will go along and we will not go beyond what the CPIB needs and is able to say.
Don't you think that this is not in line with the government's stance of zero tolerance to corruption? The moment a minister is investigated, even informally, I think more decisive action should be taken.
I think we should have a sense of reality. Information comes up. A minister is quietly being investigated. Should the CPIB tells me as PM, should I straight away tell the minister, by the way, CPIB is quietly investigating you, please have a care? It's ridiculous. Supposing I say you go on leave of absence, why? What reason do I give? He's working. He's being investigated. It's my duty to make sure that while he's working and knowing that there's a cloud, he doesn't make any steps which are going to dig the hole further or cause a problem. And if something like that threatens to come up, I will have to find some way to head it off. Why does CPIB need time to get ready for a formal investigation? Because they must have all the facts and evidence before enough to start interviewing the principal person. Otherwise, if you go in and the principal person turns up and you've announced that you've arrested him and it turns out that there's nothing in the case, I think you have been derelict in your duty. So you must make sure there's as much as possible that the case is there before you go to the minister. And when do you go to the minister? That depends on CPIB's operational considerations. Who's in town? How do they want to mount this? What else they want to do at the same time? I defer to them on these operational judgments. They know exactly what they're doing. They have a good track record and a formidable reputation. I rely on them. They asked for permission on the 5th of July. I gave it. On the 6th, I said the timing is entirely up to you. They said they need a few days. They acted on the 11th. And that's all there is to it. The reason this is here at all is because this government decided to act own self, check own self. Otherwise, it wouldn't even be here. At some point, it may have come out, and then we would have a bigger problem, but it didn't get worse, and we have started this very serious investigation because our system worked, and we picked up that something was wrong. And that is how the system is meant to work, and that depends on the leadership, on the government, on the whole ethos of our society, to frown on corruption, to have no tolerance for somebody who falls short of the standards we expect. And when something needs to be done, painful or not, we do it. No ifs, no buts, it has to be done. It has to be done. Do you think I was pleased when CPIB told me that one of my ministers needed to be investigated? I was disappointed, I was saddened, but the director knew, I knew, said, you do your duty, I will back you, and I will enable you to do your duty. And I think that's what we, as this Parliament, ought to adopt as our attitude. Rely on them, they will do their job, and in due course, everything will be settled. And I think that's the way we keep Singapore working for a long time to come.